All right, good morning, everybody. This meeting of the Escambia County Planning Board for August 6, 2024 is hereby called to order with 8 members present. We do have a quorum. If you would, please make sure to put your phones on silent or vibrate to not disrupt the meeting. And if you would, please stand and join me in the Pledge of Allegiance. I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Do we have proof of publication?
Yes, sir.
Did the publication meet all legal requirements?
Yes, sir.
I'll now entertain a motion to waive the reading of the legal advertisement. Got a motion, do we have a second?
Second.
All right, all those in favor, please signify by raising your right hand. Motion carries. The rezoning meeting minutes from the previous meeting dated July 2nd has been provided to the board members. Were there any additions, deletions, or corrections? Seeing none, do we have a motion?
So moved.
Got a motion, and do we have a second? Got a second. All those in favor, please signify by raising your right hand. All right, motion carries. The rezoning hearing package for August 6th with findings of facts has been provided to the board members. I'll now entertain a motion to accept the rezoning hearing package with findings of fact and the legal advertisement into evidence. Do I have a motion? Motion second. Great. All right. All those in favor, please signify by raising your right hand. All those opposed. Will the court reporter please swear in members of the staff? All right, the board has previously been has qualified staff to offer expert testimony in the area of land use and planning. Does anyone have any questions regarding their qualifications and ability to offer expert testimony? All right. At this hearing, the planning board is acting under its authority to make and hear recommendations to the Board of County Commissioners on rezoning applications. These hearings are quasi-judicial in nature. quasi judicial hearings are like evidentiary hearings in a court of law, however less formal. All testimony will be given under oath, and anyone testifying before the planning board may be subject to cross-examination. All documents and exhibits that the planning board considers will be entered into evidence and made part of the record. Opinion testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. Before making a decision, the planning board will consider the relevant testimony, the exhibits entered into evidence, and the law. Each individual who wishes to address the planning board must complete a speaker request form and submit it to the planning board clerk. These forms are found at the back of the table. They're the pink forms, which I think most everybody's gotten one in. You will not be allowed to speak until we receive a completed form, and please note that only individuals who are present and give testimony on the record at this hearing before the planning board will be allowed to speak at the Board of County Commissioners hearing. No new evidence can be presented at the Board of County Commissioners meeting. Therefore, all testimony and evidence must be presented here today. The planning board will provide a recommendation for each rezoning request to the BCC, which will review testimony, documents, and exhibits, consider the closing arguments, and make a final decision. All decisions by the BCC are final. Anyone who wishes to seek judicial review of the decision of the BCC must do so in a court of competent jurisdiction within 30 days of the date the BCC approves or rejects the recommended order of the planning board. All written or oral communication outside of this hearing with members of the planning board regarding matters under consideration today are considered ex parte communications. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as provided in BCC Resolution Number 96-13. As each case is heard, I will ask that any board member who has been involved in any ex parte communication please identify themselves and describe the communication. As required by Section 2-7.2 of the Escambia County Land Development Code, the Planning Board's recommendation to the BCC shall include consideration of the following 6 approval conditions. The applicant has the burden of presenting competent substantial evidence to the reviewing board establishing that the requested rezoning district would contribute to or result in a logical and orderly development pattern. The appropriate surrounding area within which uses and conditions must be considered may vary with those uses and conditions and is not necessarily the same area required for a mailed notification. A logical and orderly pattern shall require demonstration of each of the following 6 conditions. A, consistent with the comprehensive plan, that the proposed zoning is consistent with the future land use FLU category as prescribed in LDC Chapter 3 and with all other goals, objectives, and policies of the comprehensive plan. If the rezoning is required to properly enact a proposed FLU amendment transmitted for state agency review, the proposed zoning is consistent with the proposed FLU and conditional to its adoption. B, consistent with zoning and district provisions. The proposed zoning is consistent with the purpose and intent and with any other zoning establishment provisions prescribed by the proposed district in Chapter 3. Compatible with surroundings. All of the permitted uses of the proposed zoning, not just those anticipated by the rezoning applicant, are compatible, as defined in Chapter 6, with the surrounding uses. The uses of any surrounding undeveloped land shall be considered the permitted uses of the applicable district. Compatibility is not considered with potential conditional uses or with any non-conforming or unapproved uses. Also, in establishing the compatibility of a residential use, there is no additional burden to demonstrate the compatibility of specific residents or activities protected by fair housing laws. D, appropriate spot zoning, where the proposed zoning would establish or reinforce a condition of spot zoning as defined in Chapter 6. The isolated district would nevertheless be transitional in character between the adjoining districts, or the difference with those districts would be minor or sufficiently limited. The extent of these mitigating characteristics or conditions demonstrates an appropriate site-specific balancing of interest between the isolated district and adjoining lands. Appropriate with changed or changing conditions. If the land uses or development conditions within the area surrounding the property of the rezoning have changed, the changes are such a degree and character that it is in the public interest to allow new uses, densities, or intensity in the area through rezoning, and the permitted uses of the proposed district are appropriate and not premature for the area or likely to create or contribute to sprawl. At the beginning of each case, as long as there are no objections from the applicant, we will allow staff to briefly present the location and zoning maps and photos of the property. Next, we will hear from the applicant and any witnesses that they may wish to call. And then we will hear from the staff and any witnesses they may wish to call. And then finally, we'll hear from members of the public who have filled out a speaker request form and turned that in. There's one case to be heard today. The first rezoning application for consideration is case Z-2024-11, which requests rezoning of Bellevue Road from LDR Low Density Residential District, 4 dwelling units per acre, to MDR Medium Density Residential District, 10 dwelling units per acre, as requested by Meredith Bush, the agent for House of Prayer for All Nations, the owner of the property. Members of the board, has there been any ex parte communication between you and the applicant, or the applicant's agents, attorneys, or witnesses with fellow planning board members or anyone from the general public prior to this hearing? Have you visited the subject property? And please also disclose if you are a relative or business associate of the applicant or the applicant's agent. Mr. Adams, we'll start with you.
No to all.
No to all.
No to all.
No to all?
No to all.
No to all.
No to all.
No to all.
All right. Staff, was notice of the hearing sent to all interested parties?
Yes, sir.
Was notice of the hearing posted on the subject property?
Yes, sir.
All right. Meredith, are you good with having staff present the photos? Okay. Staff will now present maps and photos for case Z-2024-11.
Yes, good morning, Board. Caleb McCarty, Urban Planning Manager, Certified Planner for the county. Here for our case is our location map. This is our 500-foot radius zoning map showing the property as LDR, and the request is for MDR. This is our future land use map. It's mixed-use suburban. This is our existing land use map showing existing uses in the area. And this is a wetland map that we included. We do have an Exhibit A showing the subdivisions in the area, and also a more focused aerial map. Here's our public hearing sign as posted on Bellevue Avenue. This is looking north at the subject property along Bellevue Avenue. And this is looking south across Bellevue from the subject property. This is looking west across the subject property on Bellevue. And this is looking east along Bellevue towards Mobile Highway from the subject property. This is looking west along Bellevue Avenue. Subject property is shown on the north side of Bellevue. We did post a second public hearing sign at the rear of the subject property on Buckland Avenue. This is looking at the adjacent property from the backside of Bellevue on Buckland. This is looking east from the backside of the subject property. This is looking north from the rear of the subject property located at the cul-de-sac on Buckland. And that concludes our maps and photographs for this case.
All right, thank you. And Meredith, I'll have you come up now. And please state your full name and address for the record.
Thank you, Meredith Bush. I'm at Clark Partington, 125 East Intendencia, Pensacola, Florida, 32502.
All right, and you did receive a copy of the rezoning hearing package with findings of facts for today?
I did, correct.
All right, and then you understand you have the burden of providing by substantial competent evidence that the proposed rezoning is consistent with the comprehensive plan, furthers the goals, objectives, and policies of the comprehensive plan, and is not in conflict with any portion of the county's land development code?
Correct.
All right, you're good to go.
Thank you, Mr. Chair and members of the board. I appreciate your time. Just before I go into the criteria, I had some questions this morning regarding whether or not this was going to be an apartment complex. So I want to make it clear that the MDR rezoning that we're seeking would not allow for an apartment complex. So what the developer is seeking is single-family detached dwellings. The current density of LDR is 4 per acre. Fully built out, we would have 4.4 units per acre, so slightly larger once built out. And I understand you can't base your decision today on the proposed development, but however, just so you know. Diving into the criteria, as to criteria A, the proposed amendment is consistent with the intent and purpose of the current future land use category of MUS, mixed-use suburban. Criteria B, consistent with zoning district provisions. The proposed amendment to MDR is consistent with the intent and purpose of the Land Development Code. The parcel is across the street from medium-density residential and adjacent to low-density residential property. The medium-density residential district establishes appropriate areas and land use regulations for residential uses at medium densities within suburban or urban areas. The primary intent of the district is to provide for residential neighborhood development in an efficient urban pattern of well-connected streets at a greater dwelling unit density than the low-density residential district. Residential uses within the MDR district are limited to single-family and two-family dwellings. The district allows certain non-residential uses that are compatible with suburban and urban residential neighborhoods. The residential nature of MDR is consistent with the intent and purpose of the Land Development Code. As to criteria C, compatible with surroundings, the proposed amendment is compatible with surrounding existing uses in the area. Within a 1,500-foot radius, the applicant has identified property zoned LDR, MDR, HDMU, and HCLI. Within the general vicinity, there are residential uses, the Pensacola Interstate Fairgrounds, and various retail uses. To ensure additional compatibility with existing adjacent uses, if the amendment is approved, further review and evaluation through the Development Review Committee process may be necessary. As to criteria D, appropriate of spot zoning, the amendment request, if granted, would not create spot zoning. The property is adjacent to MDR zoning and within 1,500 feet of MDR, HDMU, and HCLI zoning. And then as to the final criteria, appropriate with changed or changing conditions. Based on the existing uses and intensities and the zoning district allowances, the proposed amendment would not create urban sprawl and would be compatible with existing development. It is in the public interest to allow the MDR zoning. The proposed rezoning will contribute to a logical and orderly development pattern. One thing that's not in the criteria but was also mentioned to me this morning is a concern for stormwater. As you know, the code requires all stormwater would be addressed on the site itself and no runoff to other properties would be allowed. And obviously with a new subdivision, they would have their own stormwater management system. So I'm happy to take questions. The developer is also present for questions.
All right, any questions for the applicant at this time? All right, if we need to get you back up here, we will. Thanks. All right, staff, I'll let you go ahead and make your presentation.
Excellent, thank you. Concerning criterion A, consistent with the comprehensive plan and all applicable goals, objectives, and policy of the comprehensive plan, we found that the proposed amendment to MDR is consistent with intent and purpose of the future land use category mixed-use suburban, as stated in comprehensive plan future land use 1.3.1, mixed-use suburban, allows residential development and different types of retail sales and services while promoting compatible infill development. In accordance with comprehensive plan future land use 1.5.1, the maximum densities and intensities are encouraged and underutilized properties in the mixed-use suburban category to promote the efficient use of existing roads, utilities, and infrastructure. Furthermore, future land use 2.1.2 promotes compact residential development by allowing rezonings to higher density in the future mixed-use suburban future land use category. Concerning criterion B, consistent with the Land Development Code, we found that the proposed amendment to rezone to medium-density residential, 10 dwelling units per acre, is consistent with the intent and purpose of the Land Development Code. The primary intent of the low-density residential zoning category, which this property currently is for predominantly detached single-family dwellings with a maximum allowed density of 4 dwelling units per acre, and to preserve the character of existing and established communities within the low-density residential suburban area. Medium-density residential zoning district is appropriate to provide transitions between areas zoned or used for low-density residential and areas zoned or used for high-density residential or high-density mixed use. MDR zoning allows for single-family, same as LDR, but with a higher density of 10 dwelling units an acre. The property to the west is a platted subdivision with the same zoning as the proposed MDR. Additionally, the rezoning to MDR is an appropriate transition between the MDR property to the west, the LDR property to the north, and the heavy commercial and light industrial property to the east. Due to the previous zoning designation of V2A, the property would be limited to single-family residential development. Additionally, in a memo dated July 18, 2024, from Transportation and Traffic Operations staff, comments have been provided concerning the rezoning request. TTO has no traffic capacity concerns related to Bellevue Avenue in the vicinity of the subject parcels. There are existing speed tables on Bellevue. Please note that TTO's review is solely based on the rezoning application submittal packet, so the comments above hold no bearing on any TTO comments made during the development review process. Continuing to criterion C, if the rezoning is compatible with the surrounding uses, we found that the proposed amendment is compatible with the surrounding properties in the area. The surrounding uses are similar to the allowed uses under requested MDR district, which is single family. Within the 500-foot radius area, all properties with the LDR, MDR, and HCLI zoning districts that consist of single-family dwellings or commercial uses on the individual lots. The abutting MDR zone property to the west is single-family dwelling subdivision of approximately 18 acres. The resultant density of the west subdivision is calculated to be 2.5 dwelling units per acre. Additionally, the LDR zone property to the north is approximately 10 acres, and also a single-family dwelling subdivision with a calculated density of 3.2 dwelling units per acre. We also added a Exhibit A subdivision map to reference that if the board would like to see that later. Criterion D, appropriate if it's spot zoning. We found that by definition, the proposed amendment to MDR would not be considered spot zoning due to the contiguous land being the same zoning and will be compatible with the surrounding properties in the area that are developed with low densities and intensities. Concerning criterion E, if there's appropriate with change or changing conditions, we found that the land uses or development conditions within the area surrounding the properties have not changed. The development within the area has remained low to medium density residential, and with the request for MDR, the potential uses, densities, and intensities allowed by that district would be compatible with the existing surrounding development patterns. The proposed amendment would not create or contribute to urban sprawl. That concludes our staff's findings for this request.
All right, board, is there any questions for staff at this time?
I have a question regarding criteria B, the traffic comments. TTO has no traffic capacity concerns. Is that based off of a maximum build-out in the event this gets approved?
So they look at the potential densities related to and the traffic impact and provide us with, comment related to the proposed densities and intensities. They didn't have any issue there. Now, at the development review process, they would likely require some type of turn lane analysis, so some additional impact if there's right-of-way that's need to be acquired and those technical things. But at this time, they did not see any concern related to the proposed densities of the requested rezoning.
Thank you.
All right, any further questions? All right, at this time, we'll move to the public. For those members of the public who wish to speak on this matter, please note that the planning board bases its decision on the approval conditions and exceptions described in section 2-7.2 of the Escambia County Land Development Code. Please note that only those individuals who are present and give testimony on the record at this hearing before the planning board will be allowed to speak at the subsequent hearing before the BCC. And we'll have you guys come up, you'll be sworn in, and you'll state your name and address for the record, and we'll get your 3 minutes started. All right, so first up to bat here is Don Tinker. Now I'll have you state your name and address for the record, and then we'll have you sworn in.
Don Tinker, 6050 Yellow Rose Drive here in Pensacola, 32526. I do. In concerns with the proposal, the property has been, vacant for quite some time, and we're not opposed to it being developed, but we certainly have great concerns. Certainly the traffic on a two-lane roadway, Bellevue Avenue, is not what everyone might hear, understand, or perceive to be real. I mean, I travel it daily, and so I know the shortcomings and the frustration. There's right now, there's speed bumps just to slow down the traffic. And then we also have heavy vehicles coming through there, cement trucks and stuff. We'd like to see it not be a, heavy vehicle traffic way. The impact as far as, drainage and things like that, that's a community problem. Some of these things have been put off as a county problem, some of them have been put off as a state problem, but we look at it as a community problem. And the development of this property is also going to impact on how the surrounding drainage issues either are resolved or get worse. So, like I said, changing it to a medium density, and the key word being density, increasing that population of occupation per se in our little community is going to have a significant impact. There's a school just right down the road that if you're coming off of Mobile Highway onto Bellevue Avenue and they're trying to get in and get their children into school, there's a backlog that's created. And sometimes you don't see that, especially when school's not in session. So if they looked at that traffic issue at that time, it's non-existent. But when you look at it during the school year, it is a pretty significant impact on what comes and goes up and down Bellevue Avenue. And then take in the fact that the fairgrounds, when they empty out during the fair and things, they use the Bellevue Avenue exit to get some of the people and traffic out of there when the fair closes. So there's a lot of variations and things that aren't being presented or maybe considered because these are factors that just take place at odd times throughout the year. I'd certainly like to just see things exist as they are with a low density rather than a medium density type development.
All right, thank you. All right, next we have Jerry Arrowood. No questions? Did you want to waive in support or against the project at all, or just you're good? Okay, fair enough. Just want to make sure. All right, next we've got R.S. Morton. Same thing? Okay. All right. We've got, I think this is Nathan Eubanks. Is that Gwen and Nathan? Okay. And we'll, Mr. Eubanks, if I could, if you would like to speak as well, could I have you fill out a separate form and we'll have Ms. Gwen go ahead and go? And then, because that way we gotta, if you want to speak at the BCC, we gotta have a sheet for each of you, is all, okay? All right, Ms. Eubanks, if I get you to state your name and address for the record and be sworn in, please.
Gwendolyn Eubanks, 4991 Bellevue Avenue, Pensacola, Florida, 32526.
Okay.
And I do. Yes, we live on Bellevue, one house before Muldoon Road, as the gentleman just spoke earlier. We moved out there because we loved it. It's family-oriented. The issue is I have grandchildren. I have children. That speed bump at my The very first speed bump on Bellevue is right in front of my house. My grandson almost got hit. I've called companies, people just come through there, bam. Like I say, the traffic, where you used to could leave home and get to work in 10, 15 minutes, you're having to leave home and get to work in 30 minutes because school traffic or whatever, and between Mobile Highway and Blue Angel, that's the cut across. It's not, it's just, it's hard. And then, I'm not opposed to housing, but it's gonna make it difficult for the traffic and just for the play. Our kids can't even go out and play unless we're out there watching what goes on. You cannot let them come play because they're just coming through. There's big trucks like the gentleman stated. It's just overall, I mean, and just when you go to digging up and messing with that kind of land, we already dealing with snakes, raccoons, we dealing with coyotes and stuff out there. So when you go to digging up this kind of land, it's gonna cause all kind of other stuff. But our biggest thing is the traffic and the trucks coming through and our children's way of life. And I moved out there for a simple life. I'm just not okay with it.
Thank you very much. All right, Mr. Eubanks, we'll get you up here. And you'll just state your name, address for the record, be sworn in, and we'll get you your time started.
Nathan Eubanks at 4991 Bellevue Avenue, Pensacola, Florida. Yes. Yes, like everybody stated, that the traffic, the understanding of children outside playing, they can't play like they want to play because of what's going on. And if you put more houses and different things across that street, you got a problem already that hadn't occurred. And water rising, and we don't know what may come. We got, like she said, we got coyotes, snakes, everything out there, and then you disrupt what's already there. Now it leads over to the property owners has to deal with what's running around in their yard. People done already had cats and dogs get killed, but now we come to a point to where, what about the children? What about understanding that the more you put out there, people move out there and understanding that, guess what, of a comfortable life, of understanding now where our property is gonna value at. When you begin to move things and put more stuff in, property value begin to drop. So we have to come to understanding of what's what. How do we get out of a high note that we already have? So however y'all look at it, you got to look at the people versus our pockets. That's what we concerned about. Because of the fact of it is, we as people, we can't keep going on worrying about staying outside, watching children, when people running up and down the road like it's a racetrack. Even though you got speed bumps there, nobody, you call the law, maybe come out there, may not. But we have to be concerned about what's happening in the residence. Thank you.
Thank you. Next, we've got Jesse Embry. State your name, address for the record, and be sworn in.
Morning, gentlemen. My name is Jesse Embry. I'm at 5011 Bellevue Avenue.
Raise your right hand. Solemnly swear or affirm the testimony about the truth.
I do.
Will be the truth, the whole truth, and nothing but the truth.
Yes, sir. My wife and I spent 8 years trying to find the perfect house for us, and we finally found it. It's right in the middle of the south end on Bellevue, looking dead at that big, beautiful open field, and I hoped it would stay that way forever. I knew it wasn't. My biggest fear was, I hope they don't put an apartment complex, and ma'am, I'm glad that's not what we're trying to do here today. That's awesome. That takes a big, big weight off of us. But the high density thing, I still don't like it, man. That's 150 more families looking dead at my house every time they leave work. I have 7 grandchildren that play in the yard, you know what I mean? I got my wife who's not too well. That's our dream home. We just bought it 4 years ago, and it's awesome. It floods. The flooding is a real issue right there, and the traffic. I don't know what the TTO is looking at, but the traffic is already bad right there. You put another 150 homes there, I won't be able to get out of my house in the morning. It'll take me an hour to get to work. The flooding is bad. I had to spend 30 grand already under my house getting it encapsulated and water pumps and all that put under there because the water rises really quick right there. And if they build up that land right across the street with the little ditch that's there right now, my house will be underwater every time it rains. That's a fact. That's true. You come down that road at any time, all of our houses across the street from right there all get rising water right there. So it is an issue. I would like to see nothing built there, of course, but it's not my land. I get it. But I disagree with the high density or the medium density. I just wanted to state my opinion on that. I hope we keep it the same and not rezone it. Thank you.
Thank you. All right, next we've got Chris Steven. Please come forward, state your name and address for the record, and be sworn in.
Chris Stevens, 5021 Bellevue Avenue, Pensacola, Florida, 325-265, or 32526. Yes, sir. It's hard to really say something that hadn't been touched. 4 years ago, we bought our house with a big sign across the street that said future home of Agent for House of Prayer. We were cool with the church or whatever building they were gonna build, and then now we're getting development. It's not something we want, but we're gonna cut it short. My wife's having surgery this morning, but she made it a point for me to be here, so I'm just gonna say I'm against it and head out.
Thank you.
Thank you.
Good luck on your way.
Kadaji Hurst, you're next. If you could please come forward and state your name and address for the record and be sworn in.
My name is Khadijah Hurst. I live at 6016 Yellow Rose Drive, Pensacola, Florida 32526. And actually, in one of the photographs, oh, sorry. The first thing I wanted to bring up, and it
Can you
will
move the mic just a little bit closer? Thank you.
Sorry. The first thing I want to do is talk about the traffic, and this may reiterate a lot of what has already been said. There is actually a apartment complex being built on Mobile Highway right after the Bellevue Middle School. I don't know how many people it will hold, but if perhaps they have to go to Blue Angel, that traffic will also turn up Bellevue to go up Blue Angel. And the problem with that is they're on one side of the road where they would have to make a U-turn. And it just, I feel like that will become a big issue just with them prior to this whole zoning matter. So I don't know if the TTO has taken that specific change coming into consideration, but I personally have a big fear of that before this even came up. And the other thing is that softly corner too, because everybody's kind of coming back across town. The Softly and Mobile Highway, there's always really bad accidents right in that big intersection. So even if it's rezoning in my area, that will cause more pileup, more catastrophic accidents at that big intersection as everybody's doing their shopping or whatever. As far as flooding, I don't have specific statistics, but I did just do a quick Google search. Escambia County apparently has 65 inches of rain annually. And when we do have those really big time frames where it rains for like 2 weeks straight, sometimes our water runoff, like as I'm coming up Bellevue Avenue, I can already tell when my neighborhood is going to be flooded because the water will have lots of water sitting in the retention that runs along the road as far back as right after the school sometimes. And we only have one exit to the Yellow Rose neighborhood. And when we can't, when I first moved in, there was a gentleman who had also just moved in, had a low riding car. He lived literally at the exit of our neighborhood. He couldn't back out of his driveway because it totaled his car. Like, it is high enough where if you don't drive an SUV, you're not making it out of our neighborhood at certain time frames in the year. And this happens, and I do actually have some photos if that needs to be presented, where it has come a little bit to my mailbox in height. Thank you.
Thank you.
Thank you.
Thank you.
And next, we have Mary Konopka. I don't know if I got that right, but Miss Mary, please come forward, state your name, address for the record, and be sworn in.
My name is Mary Konopka. I live at 6248 Muldoon Road, Pensacola, Florida, 32526. I do. I have some a point paper I made that I would like to submit into evidence. If I could approach someone to give them point papers? No?
Board, how would we like to handle this? Could we have you?
You're able to see the evidence before you admit it into the evidentiary record. So you
Okay.
can inspect it and then decide to vote on it.
All right, that sounds good to me. Does that sound okay with everybody else?
Sure.
They're all the same. I just made a lot of copies. 3 copies. I also have photographs, but I don't know how to submit them to you. But I do have them on my phone right now. And they were taken this morning. And it shows atrocious infrastructure and problems with drainage in that area. Seems like the water comes right down Muldoon Road from Bellevue Avenue. And the current infrastructure isn't really able to handle it. So I can't see putting in anything new until the old is fixed. Sewage does back up in the houses in Bellevue. The people that have spoken already that live on Bellevue may have that problem. I know that I was going to buy a house on Bellevue, and when it rains, the toilet doesn't want to flush, so I didn't buy it. But the person who did buy that house, I have met, and he has that problem. He would be here, but he had an appointment at the VA clinic, and you just don't bypass appointments at the VA clinic when you get them. Traffic is absolutely an issue, especially during the school year, especially when people and buses drop off the kids and when they pick them up. It is a nightmare to get down Bellevue, to get out of the neighborhood. If I were having to travel to go to work and leave that area to go to Mobile Highway, I could not go to Bellevue and go to Mobile Highway without waiting probably a half hour because of traffic. It's horrible. Schools, I'm worried about schools. Yes, they're building another complex in the Bellevue Middle School and elementary school area. Bellevue Elementary being there at Mobile Highway in Bellevue, and then Bellevue Middle School being right after it on Mobile Highway. Those schools are already overcrowded. We don't need more kids in schools that are already overcrowded. I can't go with that. So I am against development, especially if it's medium or high density. I would like a way to get photos to you so you can see the pictures that I took just this morning. Is there any way to do that?
I don't think so at this time unless you had them on you in a hard copy, physical copy for us to
Print
look
them out.
at before we could enter into evidence.
So there's no email to send them to?
You could send it to staff, but our decision will be made probably by the time that they get there.
And also too, and maybe our county attorney can chime in. At these proceedings, they're very quasi-judicial. That means that they're regulated by state laws and state statutes. All the evidence that got to during these hearings, the evidence and pictures and anything, they gotta be presented today at this meeting. We can't have no other additional meetings or information presented after this meeting for the board to hear. It's very. It's up to the county attorney if that can be introduced as evidence for the board.
Okay. Here's what I'm gonna say. One, I appreciate that you typed this out, and this was essentially the testimony you just gave to us, which is gonna be recorded by the court reporter. So it would be, I don't see a reason to enter this into evidence, because you just did by speaking to us. So, and I don't know if the board agrees with me
Agreed.
on that or not. Okay. But, I mean, you covered all the points here in speaking, and so that evidence has been put into the case file. As far as pictures, I mean, we've got the photos that the staff has presented to us. I understand you've got maybe photos from a different time frame or whatever it may be. And if we don't have them, a hard copy of them right now, we're not going to hold up the hearing to try and locate that before we make a decision. So that's my opinion. I don't know if the rest of the board feels the same way, but
Mr. Chair, I do agree, and I will add, and maybe Horace, you can help with this. We want this kind lady to understand her labor is not in vain, and she has good points. The points made are really not addressing the purview of this committee today, but they could be used during the development review process.
Yes.
So if we could help her and guide her there, this document would not be in vain. There may be opportunity for the photographs to make it and land in an appropriate time for consideration as well. But for what we are held to today with our 5 criteria to meet, those pain points that you're experiencing do not relate to the 5 criteria this board is considering today.
Right. Thank you for that, Mr. Pierce. And I know there was issues raised about flooding and stormwater issues. This, for any type of development, every project got to be able to maintain its own stormwater systems. And even with that, the county engineering department, they will be looking at how, during the site plan review process, if this is approved, how the project will even impact the surrounding stormwater. And basically, they're going to, if there's any detriment for this project to make the stormwater impacts worse, the county engineering department is not going to allow for that. They really looking at how it can make it better. Because see, it may, by the inclusion of, I'm not a stormwater expert, but by the inclusion of the stormwater pond for this development, they're gonna be looking at how that stormwater pond can make the other issues regarding stormwater better. That's one thing that we have to look at, not to make matters worse when it comes to stormwater, to make improvements for new type of development. They got to. So I just want to say that for flooding that may be going on, they're gonna look at it and see how they can make it better. Now, for the whole area, even for this development, they got to capture their own stormwater, and they definitely look at the surrounding development and how they can make that improvements to make that area better when new development comes in.
Well, okay, well, my final thought is on traffic because the lady here said it was in public interest which it's not, because there will only be one, maybe two exits from this development, because you got the fairgrounds over there, and you got building neighborhoods already over there and over there. So how can you have a lot of streets that are gonna exit onto Bellevue and provide relief for traffic? I don't see it.
Thank-
I don't see how TTO, I think that's what you call them,
Yes.
they haven't even been out there. I can guarantee nobody.
Thank you so
has
much.
said-
I know Mr. Adams, I know wanted to add something about the schools.
Yeah, I did. I'm School Board District 1, and there is no capacity issues right now with Bellevue and Bellevue Middle or Elementary. And actually, there's going to be an announcement later on this month by the superintendent where we're actually going to try to do something that even decrease the middle school enrollment on top of that. So anyway, now, the traffic problems for the school, there, yes, as somebody that gets called all the time on it, we got a lot of car riders, and buses transport 28,000, but the other ones, they'll get in that car rider line, and it is a problem with the older schools. New schools, we build a lot longer car rider line, actually going out on the playground just about it with a roundabout. So if more, Bellevue Elementary just went to a B school, you know, and it's getting a lot of good news, so enrollment could go up, but right now, we're okay.
Thank you.
And Chairman, I
Thank you.
recommend that the board either vote to admit or reject the document into evidence. But I think there should be I recommend
Okay.
that there is a vote on that.
I got you. All right, so I'll take a motion on the evidence that was presented to allow it in or not.
I move to reject it, for her
Second.
testimony was
Okay. We have a motion. Do we have a second?
second.
All right. All those in favor, please signify by raising your right hand. Okay, all those opposed. And I just want to make it clear, the testimony you gave
It was very good.
was accepted into evidence. It's just the written version of it was not. So,
I understand
okay.
that.
All right. Well, thank you so much.
You're welcome.
All right. Thomas Brown, if you'll please come forward, state your name and address for the record and be sworn in.
I'm Thomas Brown Sr., and I live at 6309 Buckland Drive, 32526. Yes. I guess I look back when I retired out of the military, and I found where I'm living now in 32506. It's a good area. I noticed the fields behind and to the right of my house, and the pictures actually showed my house and where I'm located. One of the things I'm kind of concerned about is like someone mentioned is Buckland Drive. Is that going to be open to allow traffic to come through that development? It's a closed road right now, but that's my main concern, and my neighbors, you know. So that's one of the things. And as everyone said, the flooding, and everyone said, but then I heard what the gentleman said, that they already looked into that. But that's a small area, and to add those in there, I think the neighborhood is really going to have problems. And on speaking for the whole area, the people I've talked to, they are very comfortable in that area and want to see it stay the way it is. I do understand we do need to continue to develop, but there are other places we can develop at. And I'm in love with where I live at, my neighbors. I love them. But if we have that over there, I think it's going to be more problems than we really want to handle. And I'm just speaking in general, and I do love the wildlife, as someone said. I love hearing those coyotes out there yelling, and the hawks and the rabbits, and we have a lot of that. I love it. That's one of the reasons I moved out there, so I would love to keep that. And my main thing is the road. If they open it, I'm going to have problems. That's
Yeah,
it.
I don't think that's part
Alright.
of this discussion.
Thank
and-
you.
Okay.
Yeah, that would be later down the road.
Later.
On the road.
Yeah. And I figured that, but I wanted to bring it up. Thank you.
Fair.
Thank you.
Thank you. All right, board. Well, I know we did have the developer. I don't know if you wanted to say anything at all, Brian, or if you're good. And I know Meredith got up and presented earlier, but you don't have to, but just wanted to make sure you were offered an opportunity.
Yeah, thank you. My name is Brian Danton. Yes, sir. Yes. Yeah, my name is Brian Danton, Danton Bruce Development, 4469 Bluebonnet Boulevard, Baton Rouge, Louisiana. Yes, Ms. Bush gave a great outline of what we're doing there, and I don't really have anything to add. I just am here if y'all have any questions or anybody has any questions for me. Thank you.
Thank you.
Good thing is you've heard what their concerns are, so just keep that in mind.
Yes, indeed.
Board, are there any questions for the applicant or for staff?
I do want to address just one thing, because, heard this more, over and over. We got a lady who's got a pink form too.
Oh, yes. She just got here.
I'll
And you can
hold
go
mine.
ahead and come on up and not read unless you.
Yeah, I'll hold it
Wait,
until
okay.
it's done.
All right. Ms. Judy Billings, if you'll please come forward, state your name and address for the record and be sworn in.
Judy Billings, 5111 Bellevue Avenue, Pensacola, Florida, 32526. Yes. Okay, everybody's been talking about this water. I live on Bellevue Avenue. We have a huge house, and when it rains, it floods. I mean, it comes up to our knees sometimes. Not all the time, but it has almost got in our house. The water is horrible. Most of these people complained about it. It is very, very true. I wished I had pictures that I could give y'all to put up there.
They wouldn't hate them.
Well, the water is horrible. The roads flood, cars flood out. It's sad. It's very, very sad. And the traffic is horrible. I'm the one that walked the neighborhood and got the speed bumps because cars are just crazy. They just line up and they speed down that road. They're crazy. But the traffic at Bellevue is awful where the school is. And that is my concern about the flood water. And you said, how much money did they spend on,
Scambia County, I guess about 15 years ago, spent $6 million on the ditches out there, and it still doesn't drain.
do you hear that? $6 million they spent? 6 million? $6 million on the ditches. We had a ditch in front of our house and my husband loved it, but they covered the ditch up and put sidewalks, which I love. And now the water comes right into our house and it's very, very scary, especially when we have bad rain, because I don't want it to come into my house. I don't have flood insurance. And that's it. Thank you very much.
Thank you.
Mr. Chair,
Yes, sir.
I just had an update by the superintendent. This Bellevue Middle is showing at capacity right now on their list, but only because we're putting in new floors for a whole new wing. So he expects in 2 weeks it'll go back full choice. Okay, so if anybody looks up there and see at capacity, it's only because we're closing down a whole wing, getting new floors put in, which is a good deal.
Good.
Yeah.
Thank you. Reed?
Yeah, I was just, it's kind of looking at the maps and looking at the area. Most of these neighborhoods were built prior to 2001, 2002. And I know the flood issues are a huge concern, and plus, along with that, some other issues. The only one that's somewhat new is kind of what says Campfire Way. I think that's a brand-new subdivision. And the good thing is the Escambia County and the development world has really learned a lot over water over the last 25 years, 22 years. Sometimes when you get a development like this, it actually helps the water mitigation because this is just flat land. And I know water does, tend to get into flat land and sometimes stay, but sometimes it doesn't. So sometimes when you see development like this, it actually helps your area. Not always, but it you know, they'll keep water on their own property. Developments, you know, nowadays do a heck of a lot better job than they did, you know, 20 years ago. And, you know, again, most of these neighborhoods are 20-plus years old, so you've got to, you know, you got to take that in consideration. My hope is that, you know, this neighborhood becomes something that all y'all enjoy in that area, and maybe with the capacity of the road, it actually keeps the people from crossing it over, because there's, you know, there'll be more people there, and usually people like empty roads to speed down. And when it's not empty roads and there's neighborhoods, they tend to avoid those because of the problems. So just my thoughts. Future looking.
Sir, you just spoke as if the decision had already been made.
Mr. Speaker.
I'm just giving my opinion.
He's given his opinion.
Mr.
We're not going to
Speaker,
take any more
Mr.
comments
Speaker.
from the crowd, but.
Mr. Speaker.
Yes, sir.
Real quick, I'd like to say that for the folks in the crowd, this particular, I've done this 9 years. This particular zoning on paper, as we do review these prior, was probably one of the easier ones, cut and dry, look, you know, with no problems, which is why it's important that you guys come and show up. And to the point that was made earlier, it's all on the record, and this is, the problem is what you're trying to do at this place is probably not going to be as effective as you want it. But it is extremely important that you continue to be part of the process through the development review. You know, when the person's here listening to the concerns. I echo the fact that typically with this, in the process, the developer and what they have to do with their stormwater and mitigation, it has most likely will improve what is a bad situation now, right now. Now that sounds like, well, you may not want to hear that, but that's just the fact. The second thing is the problem that you are definitely facing is that Blue Angel and Mobile Highway, it's a fact. It is a raceway cut off between, I've used it that way plenty of times. You know, kudos to the activism to get your speed tables in there, because that certainly will help matters. I don't know that it solves the problem. But again, this information needs to be carried from you, to the folks who are doing what their property rights are allowing them to do most likely. But I just think that it's important that you continue with your process, even if you feel the need to go with the Board of County Commissioners and speak to them about your problems, but don't quit there. Be part of the process, work with the developer. I think the developer, if they're wise, they're going to try their best to be a good neighbor. You may not like it, but I mean, it's, again, back to our property rights issue, it looks like a pretty easy one as the county's findings have fallen. That's, again, just a couple, 2 cents.
Mm-hmm. Can you pull up the aerial of this area? You go to that one. Go up one more. Okay, and this is just for me. Where's the stormwater mitigation on the development to the west of this subject property?
The one to the west?
Mm-hmm.
Yeah, I can't tell exactly from that map, but let me see.
Maybe getting caught in the wetlands to the north?
I'm guessing so. I know that where the wetlands lie is, that subdivision's fairly new. That's Tanglewood. That one's just a few years old. I would say 4 or 5 years at this point, but there may be some drainage that is going back that way. But yes, it's not clearly shown how the stormwater for that Rosewood Estates, the one directly to the west,
Mm-hmm.
is actually handled. So I can't decipher that from the aerial myself. So
I gotcha.
It may be the very far southeast. If you zoom in, there is one vacant parcel. It may be a small detention pond that lies along Bellevue. If you go to the aerial, the actual aerial, yeah, it's that piece, right? Yeah, so I'm thinking it's that larger piece that's associated with Rosewood. That's likely the stormwater area.
Gotcha.
And it may be quite small from the aerial.
Yeah,
And if I may, Mr. Walker,
We're not gonna, I'm sorry, or there's not, we can't take any more comments just because of the type of hearing we've got. But I guess that is the stormwater mitigation there on the southeast corner of this
It appears to
development.
be, yes.
And so I was just trying to Reed's point, saying that maybe 20 years ago when that was put in, that if that was the only stormwater mitigation that was placed in that subdivision, I highly doubt that that's sufficient for a development of that size, which when you look to the parcel to the east that we're talking about today, it's a very similar size piece of property with stormwater mitigation issues that are going to be scrutinized much more than they were when I believe that was probably put in, and being given the same amount of density as that development is there on the west. Anyways, any further comments from the board? Horace, did you want to say
and
something?
Mr. Walker, you and Mr. Reed, y'all was spot on with that. Again, if this moves forward, stormwater, traffic, all of those things are part of our review process. And we do have, I'm not a stormwater expert, I'm not an engineer at all, but I know that with my tenure, there have been substantial improvements to the stormwater requirements drastically. And because of all of the different rain events we've been having, our engineering department, along with our commission, they're looking at how these new developments can make the surrounding better as it pertains to stormwater. They are always focusing on how can these make these old developments better when you bring in new development adjacent or in close proximity to them. That's one of the golden rules that they're always looking at. So I'm quite certain that once if it is approved, once they start the engineer, once they start doing their historical analysis and their historical overview of the area, problems gonna be raised and they're gonna be situations where they'll have to make improvements. So I'm glad the developer is here because our engineering department, along with our access management department, that we will be looking at these things very, very carefully and closely so that we can help the neighborhood, not make it worse, to enhance it.
Look, there's only one
Or is
street
there
there.
any?
One street.
Okay.
It's a dread.
I mean, we have to base our, decision on the criteria we're given. Most of the comments and it's opinion that's going to be best suited for the Development Review Committee and for staff when this is going through the process, when they're going to develop. I mean, we have to look at the underlying zoning. That's the situation here.
Board, any further discussion? Okay, if there's no further discussion at this time, I'll entertain a motion.
Chair, based on staff findings, I make a motion that we approve the application of 2024-11.
Okay, I have a motion. Do I have a second?
Second.
Is there any discussion? Seeing none, all those in favor, please signify by raising your right hand. All those opposed, motion carries. All right. Do we have any-
This is the first step. They're approved. State line is made up. I know, but it's the first step. No, they're done.
Walker, do you want to adjourn the
So we're going to adjourn the rezoning meeting of the planning board, and we'll go into the regular board meeting for the planning board. We'll start in 5 minutes.
Actually, we have a question for you guys, if that was okay. I guess my first question is, do you know if there was any
backside of Rosewood Estates. Okay.
What's the density we're talking about?
Yeah, sure. So in the low density that it's current right now, it's 4. Our subdivision is 4.4. So it's 87 lots. So it's
That's not brick in front of our house. We have no park right here. There's no park in Bellevue.
so yeah, so I'm saying the density that we're going for is very, very minimal over the.
Right, that's what he's telling them.
And it won't be like
It's, I thought it's 87 units is what they got on the conceptual site plan. So it's 4.4 dwellings per acre.
Well,
I don't know, we emailed it to Rachel. For some reason, my email sent it to me and I couldn't open it this morning, so he's.
Very consistent. Yes, sir. Yeah, and I mean, look, that's our
My
model.
name's Joe Wright. I'm chairman of the trustees from Allen Memorial. Is our case going to be heard this week?
It's gonna be heard next, yes,
Okay,
sir.
I just wanted to make sure.
Yes, sir. They took a while to wait to let, the earlier case clear out.
It said they were going into regular meeting, so I changed it.
No, so you're on the regular, there's a rezoning agenda and then there's a regular meeting agenda. The opt-out's on the regular meeting agenda. Yes, sir. So, yours will be heard here in just a minute. And I don't think there are other citizens here, on yours, so hopefully it'll go relatively smoothly.
So right now, we're still
Yes, yes.
Wait, Jane Shockley speaks very highly of your time and her service.
Oh, I adore Judge Shockley.
Yeah, she's special. Got to know her quite a bit. My wife was the court administrator for the circuit. She just
Okay.
retired.
Robin?
Yeah.
Okay.
Yeah, she just retired.
Nice.
Thank you. She said, we'd be in good hands.
Yeah. Those were some good years in front of her.
I know she can be the man.
Oh, absolutely. You better be prepared. You better be on top. You better have spoken to your clients, know what you're doing, not any unnecessary delays. Straight to the point. Right. But fair, very fair. Absolutely fair. Yeah.
I like things like that. I'm a retired federal agent, so I'm
Okay.
familiar with the system also.
Right.
She said we'd be
Oh, good. Well, good. That's good to hear.
Just be back here and listen.
Okay. All right.
Thank you.
Question for you.
Yes, sir.
You know, although low density is like down in Yellow Drive, medium density is still residential.
So it's instead of a 60-foot lot, it's a 50-foot lot.
Yellow Rose Drive.
They may be, I'm not sure.
They're making it a lot smaller.
A little.
Still,
It's absolutely still residential.
not condos.
Not condos, not townhomes, not
Like the one on Mobile Highway, that new, that's gonna be,
Right, okay.
that's not what this is.
No, sir. This is just a subdivision.
It's still gonna be residential.
Absolutely.
Single family home.
Yes, sir.
More like what they're doing downtown, I call them shotgun houses.
No, sir. These would be nice full-size homes.
Trying to put that house on the
Normal.
More dense.
Well, so the low-density residential allows 4 dwelling units per acre. Correct. This, when it's built out, because of all the infrastructure requirements, and setback requirements, and the stormwater pond and roads and all the stuff you have to put in the development, it's gonna be 4.4 units per acre.
The planner made a recommendation.
Instead of 4.
There's the Board of County Commissioners still gotta make the final decision. So it's still not over yet.
And then that's gonna be, will it be the email in September?
It's gonna be-
Well, right, so that makes it a little easier. I mean, it seems like the notification, I mean, the extra traffic, people would need was just all being safe.
Improve the area.
We had a baby shower over the weekend, so I couldn't really plan and really organize much of, you know, what I wanted to say. But, It just seems like the notification is kind of like a short notice. Is there a way to expand it a little bit more, or?
It's not, those are governed by set rules too. These chapters, they're governed by so many rules, and we gotta go by the rules. If not, things can get overthrown for a technicality. Let's say the county would have been in favor of it. If we would have missed those deadline rules notification, we could have lost. So therefore, that's why those rules are in place, and we gotta adhere to them. If we don't,
Well, and then the other thing is, so I got 3 minutes to talk.
Yes, sir.
And then as you hear from more and more people and stuff, and then even when the board said, well, bring up that aerial and things. So some of the things that they talked about when that aerial was up, I raised my hand and I wanted to point out something that.
you can't speak anymore.
I know,
can't,
why is that?
Because these are these are quasi-judicial rules that's governed by statutes. And if we violate those rules, this board could be sued, the commission can be sued for violating these type
They
of
brought
rules.
something into question that I could have pointed out
But,
and answered for.
but the board, they can't allow for this one. Once that comment period closes out, I'm telling, we wish the board, once again in their hand, those rules govern that process. It really does.
But even you, at the end, brought in questions or.
Because I'm the staff. I work with but the neighbor and citizen participation is governed by rules because see, I'm telling you, we got 2 cases right now. 2 cases that got to come back before this board because of some things that were not done properly. I'm telling you, these rules are so hard.
All right, we need to get going here with the regular planning board meeting.
Hey, Horace.
If I could,
Horace, can we get people to
if
move this
we'll
out?
have-
Attention, everyone.
guys move out to
we
the-
gotta start. Thank
to
you.
the
We gotta start
lobby.
our next proceeding. If
Sorry,
I'll be
guys.
outside to talk to anyone, but please empty the
This is
meeting
true.
room. Let's go talk.
Alrighty.
We have no one for the opt-outs? This is kind of crazy.
I don't want you to speak it into existence.
All right, this is the meeting of the Escambia County Planning Board for August 6, 2024, hereby called to order with 8 members present. We do have a quorum. Do we have proof of publication?
Yes, sir.
Did the publication meet all legal requirements?
Yes, sir.
The chair will entertain a motion to waive the reading of the legal advertisement.
So moved.
Second.
Motion is second. All those in favor, please signify by raising your right hand. Motion carries. The planning board meeting minutes for July 2nd, 2024 have been provided to the board members. I will entertain a motion to accept the planning board meeting minutes into evidence. Do we have a motion?
So moved.
Second.
We got a motion and a second. All those in favor, please signify by raising your right hand. Motion carries. The planning board hearing package for August 6th has been provided to the board members. I will entertain a motion to accept the hearing package and legal advertisement into evidence. Do we have a motion?
So moved.
We got a motion. Do we-
Second.
Second. All those in favor, please signify by raising your right hand. Motion carries. Today, we have a public hearing concerning the review of an ordinance removing a parcel from the county DSAP and assigning a compatible FLU OSP-2023-01 that the board review and recommend to the BCC for adoption an ordinance amending the Escambia County Midwest Sector Plan, Final Land Use Plan Figure 2.01.A, removing a parcel within Section 03 Township 1N, Range 31W, Parcel 4200-000-000, totaling 3.68 plus or minus acres located on Highway 29 from the Escambia County Midwest Sector Plan. Further amending Part 2 of the Escambia County Code of Ordinances, the Escambia County Comprehensive Plan 2030 as amended, amending Chapter 7, the future land use element policy FLU 1.1.1 to provide an amendment to the 2030 future land use map, assigning a future land use category of mixed use suburban. Staff, I'll turn it over to you.
Yes, good morning. Allison Lindsay, Urban Planner Development Services. So I'm going to give you just a little quick refresher because it's been a while since we have an opt-out. So the Midwest Escambia County Optional Sector Plan consists of approximately 15,000 acres, and it's in the north end of the county from interstate north to Highway 196 and then west of Highway 29. The intent of the Midwest Sector Optional Sector Plan was to recognize the benefits of the long-range planning for areas greater than 5,000 acres and promote innovative and flexible planning and development strategies. The adoption package was approved by the BCC on January 2011, and the notice of intent to find in compliance from DEO was received February 2011. Can you put up that DSAP map? Thanks. So there are two detailed specific area plans. We call them DSAP. One is the Muskogee DSAP. It's on the southern half of the overall sector plan area, which is comprised of approximately 3,380 acres of developable land. The second is Jack's Branch, which forms the north half of the sector plan and is comprised of approximately 5,231 acres of developable land, which totals 8,611 acres of developable of the overall 15,000 acres. So in so far, the Jack's Branch and the opt-outs that we've had and have been approved, we've had 214 plus or minus acres that have been opted out in the Jack's Branch, and then approximately 94.13 plus or minus acres that have been opted out of the Muskogee. So that totals 309 opted out acres overall. So as part of the sector plan, the detailed specific area plan, it was really defined to develop standards and to identify the distribution, extent, and location of the future uses, public facilities, and any all this for the short term and the build out. So this, I can go through the maps. So this is the aerial, the location map of the opt out. It's on Highway 29, and then that's fine. And then the location. Go to the next one. So the zoning map showing currently the underlying zoning is HCLI, and the future land use is conservation neighborhood in the DSAP. And then so they're requesting to change it from the conservation neighborhood to the mixed-use suburban. And this is just showing the DSAP area outlined, the parcel in blue. And this is showing the Jack's Branch map, and the area in question is over on the east, right on Highway 29, a little south, right there at Neal Road. And then here's just it's in the Jack's Branch 52, and it shows that it's the 13.68 acres, and out of the whole 342 from the JB 52. And this is the prime soils and the wetlands map showing that they do have some wetlands and prime soils on the site. And the flood zone map shows it in an X flood zone. And here's an aerial map of the site. And this was the public hearing that was posted on Highway 29 just south of Neal Road. And this looking west at the subject property. Looking across Highway 29 from the subject property. And this is the second public hearing sign a little further down on Highway 29. And this is just an additional view of the subject site. And looking north from the property on Highway 29. And looking south along 29 from the subject property. And that's the maps and photographies. So I don't know if you want me to go into my findings or if you want to hear from the applicant. It's up to you.
We'll hear from the applicant.
Okay.
Good morning, members of the board. Meredith Bush, 125 East Intendencia. So we agree with staff's findings, but I will go through, there are quite a few criteria to consider when considering an opt-out, so I'll briefly touch on those. First, wellheads. Based on the county GIS system, the subject property is not located in a wellhead protection area. Historically significant sites. A copy of the Division of Historical Resources TRS site file correspondence is included in the submission by the applicant. There were no historical resources detected on the subject property. A cultural resources map and site roster was also attached. Third, natural resources. I actually show there were no wetlands. There are prime soils, but no wetlands on the subject property. The property is located within the Jacks Branch drainage basin within the flood zone X. The soils indicated on site include Porch sandy loam and Malbus sandy loam. As far as traffic goes, the subject properties are located to the west of US Highway 29 North. FDOT provides an annual average daily traffic count along this portion of Highway 29 of 19,600 trips. All area roadways have capacity to support the requested change in the future land use category. Sanitary sewer and potable water. Cottage Hill Water Works is the area water provider. The proposed amendment is not expected to create capacity problems for Cottage Hill Water Works. Once a project is proposed and application submitted to the county, such a proposal shall identify any other providers and determine whether septic tank service or available sewer connection will be utilized. Any proposed development will receive approval through the site plan review process. ECUA will provide sanitary sewer if applicable. The proposed amendment is not expected to create capacity problems for ECUA. Wetland and drainage. Any necessary stormwater management will be provided in accordance with the Escambia County and Northwest Florida Water Management District regulations. The stormwater system will be designed for a 100-year storm event. Solid waste will be collected by ECUA for disposal in the Escambia County landfill, which has adequate existing and projected capacity. Parks, recreation, and open space. If required, the development review process will address the preservation of open space. The applicant understands that a detailed review is required through the county's site plan approval and development review committee processes. Schools, the current school assignments for this location for the 2024-2025 school year are K-5, Jim Allen Elementary, middle school is Ransom Middle, and then Tate High. Any increase in density may or may not have an impact on student population projections. Any proposed development will adhere to the site plan review process. And then the applicant submitted a very thorough analysis of the Land Development Code articles and comprehensive plan policies, identifying a land use need particular to the scope and function of the comprehensive plan for which an amendment is clearly warranted. The proposed amendment applies contemporary planning principles, engineering standards, and other professional practices to provide an effective and efficient remedy for the identified land use problem or need. And then there are a list of, I believe, about 40 or 50 comprehensive plan provisions that are supportive of the request. Parcel size and aggregate of other opt-outs. The subject property is 13.6 acres. This property represents 0.1674% of the existing development acreage of 8,168.22 acres described in the sector plan. The total acreage of the Jacks Branch DSAP designated conservation neighborhood is 2,359 acres. Withdrawal of the applicant's 13.6 acres will result in a 0.579% decrease in developable acres within that Jacks Branch DSAP. At the time of the application, the total acreage opted out of the sector plan is 442.78 acres. And then as far as the underlying zoning and compatibility with the DSAP, the underlying zoning is HCLI, and the requested future land use category is MUS. The application includes the HCLI zoning regulations and an analysis of the HCLI with the requested flue of MUS, which would be consistent with the underlying zoning uses, densities, and intensities allowed. And then finally, prior lost development rights. Prior to the adoption of the Midwest Sector Plan, this parcel was zoned GBD. The parcel was effectively downzoned by the adoption of the sector plan, and a copy of the GBD zoning district regulations were also included in the applicant submittal. Based on that, we feel we've met the criteria and would ask that you opt this parcel out.
All right, thank you. Any questions for the applicant or staff?
I have a couple. Ms. Bush, when did the current owner take possession?
That I do not. 1998.
And with the Gateway Business District, was any residential allowed in that?
Let me check. I have the Gateway Business Residential zoning regulations included, but I'm not that familiar with them.
And while you're looking that up, if staff could provide the current zoning category closest to what GBD provided?
So GBD permitted C1 and C2, which are both commercial type uses, planned business developments, reclamation of borrow pits. Those are the 3 permitted uses within the GBD zoning category.
So
Yeah,
there was no residential allowed?
It's C2 type distribution, manufacturing, fabrication, and assembly type operations, which are completely enclosed within the confines of a building. Outside storage permitted when screened. The district was intended to enhance specific segments of the US 29 and SR 97 corridor as a visually attractive, well-planned business community is the intent of the district. Districts characterized by community serving commercial uses located adjacent to or in immediate proximity to the US 29 corridor and in immediate proximity to SR 97 at the Alabama-Florida state line.
And I think it also had, the future land use also had, but HCLI, if the future land use, you could have residential, but the GBD, go ahead.
Okay.
I saw you come
Andrew
up.
Homer, Development Services. So GBD was one of special districts that the county had put in to allow in certain areas an option for commercial uses. As you're coming into the urbanized area of the county, there were districts that were created like this. The weird thing is the old code, if you will recall, up to C1, everything was cumulative up to C1. So all those uses, if it was in the previous category, it was allowed, and so on and so on. C1 did allow for all the residential uses. That you broke that off at C2, where you stopped having those residential, and as you went up from there. The gateway districts, because they were including C2, that would have prohibited the residential uses that were cumulative to C1. Does that make sense? Short answer is no for residential. It wouldn't have allowed.
It was not allowed in GBD?
Correct.
Mr. Chair, I'll ask, if I recall, when we were talking, the DSAP, when we had this, I don't know if it's 2 years now, I'll say 2 years, and somebody will say it's 5, but anyway, we had a consultant, if you recall, and all I could think of when I was reviewing this is like textbook, exactly what they said, proximity to 29, the size. I just kept going through my memory that this, again, I guess kudos to Ms. Brown, you've had two that seem to be very cut and dry without anybody's input, exactly following the letter of how we established it before. I may be mistaken, but I kept trying to find a flaw in it, but because after time, you hear an opt-out, another opt-out, golly. And then you look at the acreage, and quite frankly, it seems fairly minute.
All right. Are there any other questions or comments for the applicant or staff? And we have no one signed up to speak.
So, yeah, again, what would be the closest current zoning district to GBD?
The HCLI.
It is.
It was a crossover.
And that allows residential.
If their request for the mixed-use suburban, and yes, those two would be
So in
compatible
essence, this could be considered an improvement in rates to develop residential, correct?
Correct. As well as commercial on the Highway 29.
And then, I'm sorry, I'm late. And if you look at the land development code on the ACLI, it says there are some uses that are prohibited if you got a mixed-use suburban future land use category as well. So there's still some controls on the type of industrial uses if you got an HCLI. That's spelled specifically out inside the land development code for HCLI. So there are some prohibitions against heavy commercial light industrial type uses.
I think his worry was residential, right, Jay? I mean,
My issue has been and is this whole opt-out process. We have a sector plan, and it's evidently not very popular. So, again, I believe it's incumbent upon the Board of County Commissioners to make a decision with that, a major decision, either do away with it or or continue with it. But the opt-outs are kind of, I've said it before, it's a death by 1,000 opt-outs.
All right. If we get no further questions for either the applicant or staff, we do not have anyone sign up to speak from the public. I will entertain a motion at this time.
Move to approve OSP 2024-01 as presented.
We got a motion. Do we have a second?
Second.
Any further discussion? All those in favor of the motion, please signify by raising your right hand. All those opposed? All right, motion carries 6-1. All right. Thank you, Ms. Bush. Now we've got a public hearing concerning the Warrington redevelopment plan update that the board review and recommend to the Board of County Commissioners for adoption. The Warrington redevelopment plan update to extend the time certain to complete its redevelopment objectives. And I think we've got someone calling in for this.
hey, where's Max? We don't have MCRA.
Oh, they.
Yes. We'll find out. All right, I'll put you on speaker. Okay. Let's see if it works. So I've got Max Rogers from CRA on the phone, on the speaker. So let's see how.
Hi, this is Max Rogers. Can you hear me?
Hey, Max.
Yes.
Hey, thank you for accommodating me. I tested positive for COVID over the weekend. I'm feeling better, but just not sure how quite contagious I am at the moment. What we did here is we updated the Warrington redevelopment plan. Very similar to what we did in 2010 was the last time we updated the plan. So this is the 2024 update. What's remarkable or of importance for this update is that we are looking to extend the time certain to complete the redevelopment objectives, meaning that if we do not update the redevelopment plan now, the Warrington CRA will sunset in December 2025, which is the 30-year time span that was initially created for the Warrington CRA. But what we found was there is still blight in Warrington. Average incomes are still 30% lower than the rest of the county. There's a higher incidence of crime. Housing conditions still show lots of need for improvement. So there is still a need for the Warrington CRA to go forward. And what we'd like to do with this redevelopment plan update is to extend the time certain to complete its redevelopment objectives for another 30 years as allowable under Florida statute, which would extend the sunset date for the Warrington CRA to December 2055. Included in the update is also we had a series of public meetings with the community in April and May to get input and work with the community in this process. We looked at the objectives, which we left the same as the current plan has, but what we did is update the strategies, including more specifically the neighborhood strategies, to make sure our capital improvements are better reflective for the changing needs for the different neighborhoods. And we also updated the capital improvement project list. So we completed most of the capital improvements that were feasible from the 2010 plan. So we created new capital improvement projects based on those objectives and strategies. So that is the update for the Warrenton redevelopment plan. But the important part here is that we're looking to extend the time certain to complete the redevelopment objectives, which would keep the Warrenton CRA from sunsetting in next year and extend it to December 2025. So I'll go ahead and mute my phone, and I'll put the volume back on YouTube so I can answer any questions.
Anybody have questions?
Well, not questions, but I mean, I'm the vice chair of the Warrenton Redevelopment Committee, and, you know, I will say Max has done a phenomenal job with this. I will look at the parallels with the city and stuff like that with similar projects, and what he's been able to do here with this, he's done a great job, and I think he deserves kudos for it. And we look forward to this being hopefully, you know, adopted for the future. This is something for the Warrenton community that is important, and the TIF funds do benefit the community there. I will say that. So.
Max, what percentage of the TIF is owed from the property tax revenue? What percentage does the CRA capture off the increase?
All of our CRAs are at 75%.
And what's the Warrenton CRA income currently on an annual basis?
I believe it's about 1.6 million per year.
Do you have projections of where that's headed over the next 30 or 10?
I don't. We didn't do the calculations, but I imagine it's going to slowly start to increase.
What's the base year for the Warrenton CRA?
1995.
What's the value of the property tax the county collects off that valuation from the base year?
So last year I think it was around 1.6 million. So
the county's getting 1.6 and the CRA's collecting 1.6?
Correct. Into the
about
Warrenton
half and
TIF,
half?
Yes.
Are there any policing programs in place right now in the Warrenton CRA that are being funded?
No, we did policing efforts probably in the 2010s. It's been a little controversial. The staff has found that there's been no measurable decrease in crime. There's also been an issue of having the police officers or the sheriff's department taking calls outside of the area. So, you know, as backup, that it wasn't necessarily dedicated to the Warrenton area when we were paying for it. So it is something that's allowable. I know from higher up above me that it's not seen as favorable as that it's really accomplishing anything, but I guess it could be considered in the future.
Yes.
We gave land to the county for a substation down there. It's right at Warrenton Elementary School. So it was probably about 2010 time, wasn't it? Somewhere along
May
there.
have been before that.
Yeah.
It's been there a while.
So they got a substation in Warrenton.
Okay.
Those aren't funded through the TIF, though. No, you can't take that from fire departments or law enforcement.
Gotcha. Sorry, I'm peppering you with questions here, but so what are the major program expenses for the Warrenton CRA?
So probably one of the biggest reoccurring one is the actual just paying for the streetlights. We spend about $450,000 a year just to keep the streetlights on. So that takes up a huge chunk out of it. But we also have our grants programs. We have residential improvement grants, commercial improvement grants, and commercial mural programs. That's a brand new one. But so we're looking to extend our grant programs and get more done as a public-private partnership. As you may be aware, the commercial grants have been on hold for a few years, I think since probably about 2017 or so. But recently were approved by the Board of County Commissioners to begin again. So we do set aside money every year to do those programs. We also do low-income roof programs that anyone in the Warrenton CRA, if they income qualify and their house is homesteaded and their roof is in poor condition, they could get a brand new roof for free. So that does also come out of the grant program.
Gotcha.
Can we put up the boundary map for this too?
Yes, so the boundary does not change. So that's important, is that the boundary, there's been 3 changes over the course of the Warrenton CRA, three boundary expansions. Only one is notably large, and that was, I don't have the information in front of me, but I think it was 2001 where Beach Haven and Navy Point were added. There was a small amendment where the extended stay at Old Corey and Brankus was added into the map, just that one parcel. And then there was another small change a few years later in South Beach Haven where I believe the boundaries were cut across certain parcels and they were just cleaning up the map. So there's been no changes besides that one substantive change, I think in 2001, where Beach Haven and Navy Point were added. So there is no proposed changes to the Warrenton CRA geographic area.
Sounds good. I was just curious what the exact area was, so I appreciate that. And then I'll just say, for my part, as far as, crime and safety go, in my day job with the Downtown Improvement Board, we partner with the Urban Core CRA in the city of Pensacola and fund 4 positions for Pensacola Police Department at the tune of probably close to $300,000 a year. It was two officers. Now it's gone to 4, and I think the CRA downtown is looking at adding a 5th position to kind of manage that now group of officers. But and I know the Urban Corps rakes in quite a few dollars, probably more than the Warrenton CRA district is currently. But just a thought of reaching out to our neighbors just across the bayou there with Victoria and maybe even Officer Partrick, who currently leads that program, or Chief of Police Eric Randall, to see what steps they've taken over the past few years that we've been running that program. We certainly feel that it's been an advantage for folks in the DIB, and then also I think the Urban Core CRA members would agree as well that we've seen a decrease in crime. We've got better call times to those areas, and certainly maybe worth a program to look into for this area. And I know Commissioner Kohler sits on the DIB and has seen the work that program's done in downtown Pensacola, and I think he'd probably be somewhat favorable to an idea of that in the Warrenton CRA district if it's financially feasible. And also you've got the funding to have the staff there as well, which is also another issue, but just my 2 cents.
Okay, yeah, thank you. We'll take that into consideration.
Any further discussion? And then we need a motion to approve or send a recommendation. That's what we're looking for.
I make a motion to approve, I guess.
All right, we got a motion.
Second.
We got a second. Further discussion? All right, all those in favor, please signify by raising your right hand. All those opposed? All right, motion carries. Thanks, Max.
Thank you. Thanks for accommodating me.
All right, so that is the last. I don't think we have any public comment, any updates from staff.
Drew, go ahead.
Sounds fun.
What, September? Okay, September 10th. We're going to have a second round, I would say, with the Motley Court, that rezoning. If y'all remember, it was quite contentious, went to the BCC, was turned down, court sent it back. So, considering all the factors involved, I would pack a lunch.
Too much water under the bridge. Can you remind me?
Okay. Yeah, so this is the one.
Getting sick.
So Motley.
Mr. Reed, you just got voted back in. It's too late to get sick now, my friend.
So this is out by Gulf Florida Power, the Christ plant, 10 Mile, I think it is. Yeah. This is so Motley Court goes straight north. There's a subdivision up there. Everything feeds down through that one road. On the east side of the road, partway up, there's two parcels. There's a church that is in there, and they also, I don't know if it's the same church, own the property behind them that's woods. Unfortunately, contains their stormwater pond. So it's, I think, approximately 7-acre flag lot, and they wanted to rezone to, or upzone to MDR, I believe it was. So, yeah, their first request was for HDR, then they requested MDR. So, we will take care of sending out the notices, the advertisement, and we'll see where it goes.
So how did it came through here, approved, went to Board of County Commission, they denied it. The developer, whomever, sponsor, took it to court, it's come back here. We start over.
Correct. The circuit court quashed the decision of the BCC, and the BCC remanded it back to the planning board.
Say that one more time.
Commissioner that they said wasn't allowed or something. There was something interesting with that, wasn't there?
Correct. Recommend reviewing the record on that order.
And we'll provide that as part of the packet.
Can
meeting
someone
packet.
recall?
Something kind of notable is what the effect is of something notable is the effect of a quashing by the circuit court has, or what exactly happens after that quashing takes place. Case law has shown that it's as if the BCC never made that vote to deny the rezoning. So everything that they could previously do, they can still do. The circuit court did not provide other instructions, so the BCC, it's their discretion on how to handle it, and they decided to remand it back to the planning board.
Is that case closed, or is our vote going to be a part of that case?
Let me say something. We're just giving you general information at this time. General, I strongly, I don't want to get into any more. Just be prepared. The county attorney, they gave you a gist of the overall overview, because we don't want to get into anything that may cause more additional challenges on this. It's very, very, so. All those questions, save them, write them down.
I would, I would almost say, I mean, I think we probably should end this conversation and move on. Yep. All right, thank you for the update. And with that, we stand adjourned.
If you could we, I had one item I wanted to bring up.
Sorry, I apologize. We aren't adjourned just yet. I'm sorry.
Too quick, that's okay. We have the 5 criteria that we're tasked with evaluating these rezonings on. Could we pull up the land development code, specifically 2.7.2? I'll try to be quick. But we have the 5 criteria, and then there's a paragraph that follows that talks about board action. And it's been brought up, and I think today it kind of applies, and it's. It's 2.2.7.2 Bravo 5. If you find the 5 criteria,
It's what the board can look at. That's what I'm
yes.
referring to. What the board can look at. Additional criteria that the board can look at.
Board action. I'd like to make a recommendation that we add this into our calculus. And like for today, I think it's covered. If you read that, read paragraph 5. We talk about everybody talks about quality of life, reduction in property values, and adverse impacts on the surrounding properties. I know we all think about the fact that we're one step in the process. There are other steps that follow with the development review. And it's, our understanding that a lot of this stuff will be addressed in those other steps. But I think it'd be important that we put this right up front when we hear these cases so that the public understands that we are looking at it, we do consider it, and it's part of our decision matrix. Again, it's a thought.
I'm more than happy to do it, and I brought this up last time, and I'm with you. It says the board shall then consider whether, it says it plain as day. This is in the code. I know some of us up here don't agree, and that's okay, but I'm fine with that.
Remember, rezonings are quasi-judicial hearing. It's one thing to add a statement that says this paragraph, that what you as the board are gonna do, shall. It would be different if this was a criteria, because some of these are a bit nebulous, and, who's the expert to say, diminish quality of life, lower their property values.
So
Somebody's
when would
gonna
I
have-
use that paragraph when I'm making a decision?
Well, that's what I'm saying. It might be a challenge if that was put in as one of the criteria. But maybe some statement that says, hey, by the way, because, you do have the script, maybe work this into that somewhere.
And like, do is spot on. This question has happened before. And as a matter of fact, we looked at it again, and we will look at it with the county attorneys again. And because it was my take that this was specifically for the BCC to look at, to give them a little bit more latitude and things like that. Because we do try to incorporate in our findings compatibility, adverse surroundings, impacts. But as Drew stated, property values, those are much more, and we have had cases recently where, in some of those cases, the judge looked at, said those got to come from by professional. So so cases that we have sort of had our hands spanked on, and they going through different cases, and they mention about property values, and that really have to be done by professional people. But we would definitely engage with our county attorney's office again. For us to say we're going to look at these things, I'm telling you, I think we may be opening up something that we may not be able to.
Okay, and the way I read this as well is the only time you use this paragraph is if the board agrees that the applicant has met and made substantial and proven the previous criteria, but may want to make a decision to reject the zoning change.
I think
That, to me, is where that paragraph comes into play.
Yes, I believe you're correct. That's where there is a bit of a gray spot here. And Rachel had just pulled up the notification she sends out on the back side. It's got the criteria, but down at the end, it's got that very paragraph. So the citizens are getting this as part of their notification for the hearing. It might be best, like you said, to kind of emphasize this during the actual hearing.
But just with understanding that there are certain things that you have to really be factual based, especially with quality of life, because that's so very, very subjective, and I know that Mr. J been doing it a long time, that's very, very, property values, and Mr. Reed, those are, so I just want the board and with advice of the county attorney office to be careful so that we won't, y'all be undersued for not following the board, y'all, so that's all I'm trying to
Right.
protect y'all.
And I'll add one more thing, and then I'll let other folks jump in here. But I mean, I cannot think of a time that we have sat here and listened to staff and the applicant agree on those 5 things and us sit here and deny it. So it would have to be some extreme circumstance where that didn't happen, and we would need to make a case, a big one, that overrode those 5 criteria from my view. I'll let anybody else chime in too.
So let me just, I'm on clarification on this, just for my own personal. Of course, it does say the board shall, but then it also comes in and says, proposed zoning will likely diminish. And I think y'all just said this, and I just want clarification. That's not us determining that. That is the expert, somebody up there. And if they say that, yes, these criteria, life will diminish, property values will diminish, and they're an expert, and we've qualified them as expert, then we can go back to this rule and say, yes, based on this criteria of us saying diminishing quality of life, we have the ability to approve or deny, most likely deny, based on that. Is that what I heard y'all saying?
It would be difficult to
Yeah.
to
that's
qualify
it.
someone as an expert in quality of life.
I don't disagree with you. I'm just making sure that you're not looking to us to make a determination of, we think that the quality of life, or a member of the community
Yeah.
thinks the quality of life.
That's a tough one.
That is not what to me, that does not say that.
That's what got me concerned about the idea of putting that as one of the criteria and everyone testifying on that. We're going to have.
Mr. Chair, Mr. Engwell specifically, may I suggest that I think you're right that the number 5, the emphasis should be more towards the applicant, in my opinion. When I look at the zoning changes, I think there's a unwritten, and I think it should be written, incumbent responsibility of the applicant to do their best to sell their product. And quite frankly, I know several that walk in here who could give a rip about the neighbors or the people, and you can tell. And they're just like, look, we go by the 5, and appropriately so, because of the quasi judicial. It should not be subjective. It's very objective. These are the rules. The subjectivity comes in, if they want to make their path easier, they should take note of that and perhaps try to sell it, have their own little charrette meetings, do whatever they should do so that they make their own life easier. And for some reason, it seems like we never emphasize that, or they just throw it out there and go, good luck, guys. Hope it works for you, and make your decision, and infuriate the people that think, oh, this is a sham. And I think there should be more burden put on the applicant to realize that we do have the ability to take some of these subjective items in question.
No,
So
I
it-
agree.
keep-
And,
keep-
again, but the intent is, I think it would build if we address it formally, it would build confidence in the adjacent landowners that we are considering these things. And again, it could put the pressure on the applicant to address these things.
It's always going to be the applicant's case to make. They're coming before you seeking an affirmative action. We run into this quite often at the Board of Adjustment where they say, yeah, I agree with the staff's findings, and they want to go sit down. Well, staff isn't here making your case for you. You still have to address it and make your own case. That's why if there's a tie, they lose. They need they're seeking an affirmative vote. So it's always their case to make.
I mean, I'll go by the basic fact here is we're going by statutory stuff in terms of the objectivity of the 5 criteria. I mean, we have to stay inside of that realm. Anything else, it's kind of opinionated and it kind of goes off canter from it. I understand that people come up here and want to say quality of life, but that's one of the reasons why we have the criteria. I mean, quality of life is subjective. I mean, that's a tough thing to say. A person that lives in the city is different than a person that lives in the county or the rural area. It's a glass half full, glass half empty type of scenario. That's why the criteria kind of makes this so that we can fit it into that box and say, hey, this is how we make our decision, and go from there.
But again, paragraph 5 is in the land development code, and it states that it's board action, we shall do this. It's
But again, I really think that we, give us the opportunity, because see, we have to look at the way, the entire section, to make sure that this applies to you and not the BCC. There was some questions about, does this apply to the planning board, or does it apply to the BCC? So give us some, I don't want us to say, I just want to be, so we go back and read and look at it carefully, and then we'll give it the county attorney's office, and he can provide, he and the office can provide, because these are, I don't want us to cause any more challenges for the planning board, and these cases being thrown out because we're not being governed by the black and white language of the land development code as it flows. We have to look at everything, not just one paragraph. We have to look
Well,
at the way it's written in totality.
That
That's
sentence
all I'm
actually
saying.
says the board shall recommend approval to the rezoning request to the BCC. So it actually is pointing to us, that the no new uses, density, or intensities of the use of proposed zonings will likely diminish quality of life, reduce property values, confer a special benefit, so on and so on. So that it is directly talking about us, this board here. I just don't like the will likely diminish that.
Right.
We've talked about, at lengths about how words mean something.
Yes, it does.
And I really miss,
Tate.
yeah, Mr. Tate, and he was so great about pointing out those words.
Yes, he does. Yes, he
And being very, demanding that they made sense, because that, to me, that will likely diminish, that's just puts too much of a burden
Yes, it is.
on a very subjective part of the board's actions. And I agree that it should say something more of the line that the applicant needs to make sure that, they have looked at the quality of life, diminishing values, and they will or will not, done some sort of study or whatever, that it will not, affect the people around them. But again, that's overly subjective. I hate those type of words and anything that is quasi judicial.
Yes, sir. And judges do take those little words, and they can overturn any decision. So I want y'all to be careful with saying that we want to start based on those things. But we could look at it, but I just don't want to say to do it right now. We need to make sure.
We don't want to do it right now, but we'll be back in a month. And I agree. I kind of agree with what everybody said, but I'm just saying it's there. We've had people point it out time and time again. Can we get an answer on it and figure out how we move forward?
Yes, you can.
Cool.
The county attorney's office is here.
Thanks. Is that fair? All right. Now we'll stand adjourned.